Greetings and welcome to Patent Insider Secrets, saving you from IP disasters. This is a podcast where we dive deep into the hidden world of intellectual property with captivating stories and expert insights. I'm your host, Tariq Najee-ullah, federally registered patent agent, veteran 10-year USPTO patent examiner, startup mentor, and IP strategist. Today, in episode 3, we're covering the third pillar of intellectual property, IP enforcement and defense. This is the moment where all your hard work in developing and protecting your IP can be leveraged, especially when others try to benefit from it without your permission. We call this episode the pop group and the dolls. I also like to call it the fighter. Let me tell you a story. It's the story of a retired musician. A mother who, along with her daughter and her daughter's girlfriends, created a small pop group. They had moderate success, but then something magical happened. They began to resonate with young girls across the country. In fact, their fashion, their style, and their entire vibe just started trending in schools. Young girls loved their look, started imitating. And you know what comes next, right? A major doll company took notice of the group's influence, and what did? They created a line of dolls based on the group's look and likeness. And not just any dolls. These dolls were wildly successful. The company made millions in sales, cashing in on the group's image without asking for permission or giving credit. And worst of all, the group didn't see a single dollar of their revenue. What do you think happened when this retired musician who knows the business got wind of this? I imagine it was something like this. Hi, this is retired musician. I'm calling to discuss the royalties we're owed for the doll line your company released. It's clear the dolls are based on the look of our group, and I believe we're entitled to compensation. Royalties? I'm not sure what you're talking about. Those dolls are just inspired by current trends, and we don't owe you anything. But those trends are directly tied to our group. It's our image, our likeness. You're profiting off our success without our permission. I'm sorry, but I don't think there's anything to discuss. Have a good day. And just like that, she was stonewalled. Now, I'm sure a musician probably went through an attorney if she had any actual conversation with them. The bottom line was the toy company refused to acknowledge the group's contribution to the brand. They thought they could get away with it. I mean, after all, they were a huge company. She was just a has-been musician with some small pop group. What could she possibly do, right? But here's where things take a turn. The retired musician had one thing on her side: her intellectual property. She knew her rights. She had spent years creating and nurturing the group's image, and she wasn't going to let someone else take it from her without a fight. So she did the only thing she could do. She sued the toy company, and it switched straight out of Law and Order. Now, IP enforcement. We've been in the forefront. Now, IP enforcement is not always an easy path. In fact, it's expensive. It's time-consuming, and sometimes the odds are stacked against you. But in this case, the retired musician had a strong claim. The dolls were undeniably modeled after the groups. I imagine the courtroom scene played out something like this. Your Honor, it's clear that the defendant's product, these dolls, are not just inspired trends. They're a direct representation of my client's pop group. The hairstyles, the clothing, even the accessories. Everything is copied from their carefully cultivated image. And yet, my client has not received a penny in royalties. Your Honor, my client creates dolls based on market research and trends. There is no direct link between my client's dolls and the patent's pop group. It's simply a coincidence. We'll see what the court has to say about that. The evidence was too clear. When you look at this, you see, I mean, these are exact copies of the promo and the concerts, the costumes. And they took this existing line of dolls and created a version that was basically crafted after these image and likeness of the girl group. So what happened? The jury saw it for what it was: infringement, plain and simple. And the retired musician won big time. The court awarded her a substantial amount in damages. Not only did she get the compensation for the sales of the dolls, but she also secured future royalties on any products based on the group's image. The victory was huge, both financially and in defending her intellectual property rights. And I know this sounds like Teresa's making up a story. It may sound like something out of a movie, something that's made up, but it's not as fictional as you might think. In fact, something very similar happened recently in the world of pop culture. I don't know if you're familiar with T.I., the rapper, Clifford Harris, and his wife, Tamika Tiny Harris. T.I. is a rapper out of Atlanta. Tiny Harris is a singer, formerly from the girls group Escape, songwriter as well. She and her husband, they sued the popular L.O.L surprise dolls after alleging that the L.O.L surprise dolls O.M.G line copied the likeness of members of the now defunct girls group O.M.G Girlz, a teen pop group that included Harris's daughter. And after a hard-fought legal battle, they won a massive $71 million lawsuit. $71 million. I mean, this is a real life, real world, perfect example of how enforcing your intellectual property rights can lead to huge financial victory, especially when others try to profit off your work without permission. I mean, check that out. What's the real lesson here? Intellectual property is only as powerful as your willingness to defend it. The pop group's image was their IP, but it meant nothing until they enforced their rights. So when we go back, you can have the IP asset mindset. You can develop and fortify your IP asset, which this group had done. Defending it is key to ensuring that your asset is yours to benefit from. Now, if you work hard to develop your IP, don't let others steal it. Be prepared to enforce it when necessary, whether that means sending a cease and desist letter or taking it all the way to court. Because at the end of the day, your intellectual property is your asset, and defending it is key to ensuring that asset is yours to benefit from. Now we're going to give you even more behind the scenes about the case. So back in the early 2000s, well, really the 2010s, Tiny Harris formed a teen pop group called the O.M.G Girlz, which included her daughter and two other girls. The group is well known for their unique and trendy style. We're going to look at the details of the case. T.I. and Tiny won $71 million a lawsuit against the maker of the popular L.O.L surprise dolls after they alleged that the brand's line of O.M.G dolls, so they had a line named O.M.G, similar to the O.M.G Girlz, copied the likenesses of members of the now defunct, and that was founded 15 years ago. So after a three-week trial, federal jury in Orange County, California, ruled toy conglomerate MGA Entertainment violated the intellectual property rights of the O.M.G Girlz with 7 of its dolls after T.I. and Tiny's lawyer accused the company of bullying and misrepresentations. The damages awarded to the couple included $17.8 million in real damages, the profit the company said it made on the dolls in question, and $53.6 million in punitive damages. Throughout the trial, the 3 original members of the O.M.G Girlz, Harris's daughter, Zonique, Star Pullins, as well as Baja Beauty Rodriguez, and Brianna Baby Doll Womack reportedly testified that the dolls copied the band members' looks from specific public events, and attorneys cited social media posts from fans who assumed the dolls were inspired by the band because they looked so familiar. Argued that the company did not misappropriate the identity of the music group. The dolls would not be mistaken for the short-lived band. The O.M.G Girlz broke up in 2015, and the group suffered no actual harm or lost business opportunities. The latest lawsuit is the 3rd time T.I. and Tiny have tried to sue over the dolls, claiming MGA Entertainment stole the look of their group of a young multicultural women and committed cultural appropriation and outright theft with their product. The first case ended in a mistrial, and the second ended in a win for MGA before the verdict was overturned on appeal. MGA Entertainment can still appeal the most recent verdict, though representatives did not immediately respond to the Forbes request for comment on the company's plans Tuesday. So what do we see? We see that the Harris family decided to take legal action. They filed a lawsuit against MGA Entertainment, alleging the dolls were blatant infringement of likeness and brand image of the O.M.G Girlz. So it wasn't just about the aesthetic similarities. It was about the core issue of someone profiting off of someone else's creative works. We see here in the images that the costumes were just like the girls' costume, down to their self-performance and everything. So this is a prime example of why it's so important to protect and enforce your IP. Even if your brand or creative work isn't actually in use, that doesn't mean others have the right to use it without your permission. So likeness, style, creative identity, these are all valuable aspects of your IP, and they need to be defended. The Hairspray family understood the long-term value of their creation, even though the OMG Girlz were no longer a functioning group, and their willingness to fight for that IP ultimately resulted in a significant victory, both financially and legally. The case also sends a strong message to other companies in the toy and entertainment industries. You can't simply take inspiration from real-life individuals or groups without proper licensing or permissions. Brands, especially those with creative expressions like music groups or entertainment ensembles, deserve and require protection. The $71 million award wasn't just about doll sales. It was a statement on how much value intellectual property holds, even in situations that might seem small. In this case, the line between inspiration and infringement was clearly crossed, and the court rightfully recognized that. So as you think about your own IP assets, remember this story. Whether you're an artist, entrepreneur, or an inventor, protecting and enforcing intellectual property is critical to preserving its value. This case highlights the importance of understanding your rights and taking action when those rights are infringed upon. You have to stay vigilant, protect your creations, and never underestimate the value of your IP. Even if it's not in use today, you never know when someone else might see an opportunity to profit from your hard work. So that's it for today's episode from Patent Insider Secrets. In this episode, we've explored how enforcing your rights and defending them can lead to real-world wins, not just in terms of conversation, but in terms of protecting your core creativity and business identity. I'm your host, Tariq Najee-ullah, and I hope you'll join me next time as we delve into pillar number 4, IP commercialization. See you then.